Good evening, everyone. So, we had a motion to dismiss filed by Wayfarer about 6 days ago now. So I want to just get into it because there's so much happening in this case. But basically, so if we recap the Harco lawsuit, that is essentially so Wayfarer had an insurance policy they took out with Harco National Insurance Company. There were a few others, I think. I think there were about 4 or 5 all in all. Harco has so they went to Harco, asked them to indemnify him in the Lively action, and Harco kind of waited until almost the claims were dismissed, and then they decided to decline. So Harco then rushed to New York and filed a lawsuit with New York. Wayfarer have since gone on and sued the other insurance companies in California because I think they all declined indemnification. And where we are now is Wayfarer have now responded to Harco's complaint with a motion to dismiss or stay. And I won't go into this in any great detail, but the reasoning for declining was, I think there were two policies. So there was a policy in the year 2023, and then the policy was renewed for 2024. And what happened is, what the rationale from Harco is that Lively had made these allegations in 2023. Wayfarer had signed the 17-point demand for give me a PGA credit. And basically Harco, and I'm sure Lively was inspired by this argument in her recent request for sanctions. But Harco was saying, well, from that signing that document in November 2023, you should have told us these are circumstances which could give rise to a claim where we might have to indemnify you, and you didn't say anything. So, and then we renewed, and you still didn't let us know for the new policy. And what they're basically declining to the insurance claim from Wayfarer on is the prior knowledge clause, that Wayfarer had prior knowledge that a claim may be coming. So Harco have declined it on that basis, that Wayfarer did not notify them. So, because it's not because they're being sued for defamation, because the insurance policy covers all of that. So that's basically the gist of why we are where we are. The confusing thing I don't understand is Harco is not a New York company. Wayfarer clearly not a New York company. I'm not entirely sure why Harco is filing in New York. So I think I've got Wayfarer's motion to dismiss and or stay, and I think they also sort of say, well, hold on a minute, why are they bringing this action in New York? It makes no sense. Even though the Lively case is in New York itself, in a New York court, both Lively and Wayfarer are arguing California law applies, and Judge Lyman did apply California law. So we'll read this. Okay. Defendants Wayfarer Studios, It Ends With Us movie, Justin Baldoni, Jamie Heath, Steve Sarowitz, the insureds, by their undersigned counsel, respectfully submit this memorandum of law in support of their motion to dismiss, or in the alternative, stay this action brought by plaintiff Harco National Insurance Company. Harco filed this action, seeking a declaration that the insurance policies issued by Harco to Wayfarer do not provide coverage for the claims in Lively v. Wayfarers, the Lively lawsuit. Independently, the insureds filed a separate lawsuit in California addressing similar questions. Wayfarer Studios against New York Marine and General Insurance Company. Now, this is in the California Superior Court. It's a state case. It's not so easy for me to access as federal cases are. It's not on PACER, and it means paying for, like another set of court filings, basically. I have figured out how to do it. I needed the case number actually to be able to do it. And I've just started accessing some state lawsuits, including the lawsuit brought against Brian Friedman's law firm by Travis Flores' widow. So I will catch up with this, but I haven't looked at that filing yet. So I'm as far as the California lawsuit goes, I'm going into it blind. Anyway, I will catch up with it though, and I will do something on that. In the California lawsuit, the insureds sued certain of their other insurers, New York Marine and General Insurance Company, QBE Insurance Group Limited, and certain underwriters at Lloyd's and other insurers subscribing to policy number, there's this policy number, collectively the insureds allege that the other insurers, like Harco, owe a duty to defend them or pay their defense costs in the Lively lawsuit, breached their duties, and have acted in bad faith. Had Harco not filed this lawsuit in New York, it could and would have been a defendant in the California lawsuit. There is no question that California is an available forum and that a California court is well suited to address issues under policies sold and delivered in California to California insureds. And we have a footnote. Yeah, so they're saying here, footnote is defendant is a California limited liability company. They're talking about the insurance company now. They're talking about Wayfarer now. Defendant is a California limited liability company, does business in and has offices in California, and the Harco policies were issued in California. So far, so fair. This action should be dismissed or stayed in favor of the available California forum and the California lawsuit under the abstention doctrines stated in Brillhart versus Excess Insurance Company of America and reaffirmed by Wilton against Seven Falls Company. Harco is one of 4 insurers that issued policies to the insured promising coverage for, among other things, claims of defamation and that the insureds committed wrongful acts. In other words, for the precise kinds of claims alleged in the Lively lawsuit. Other insurers involved in the insurance dispute are parties to the California lawsuit. Should this action be dismissed, the insureds intend to add Harco as a party to the California lawsuit. Litigating substantially similar insurance disputes in both New York and California simultaneously risks inconsistent results and prejudice to the insureds. Pursuant to the Brillhart-Wilson doctrine, where a district court is presented with a claim, it should ascertain whether the questions in controversy between the parties to the federal suit can better be settled in the proceeding pending in the state court. This may entail inquiry into the scope of the pending state court proceeding. Further, in the declaratory judgment context, the normal principle that federal courts should adjudicate claims within their jurisdiction yields to considerations of practicality and wise judicial administration. This court should dismiss, or at the very least, stay this action in favor of the California lawsuit. Continuing this action, while another action with overlapping issues is presently being adjudicated in state court, would waste judicial resources, risk prejudicing the insurers by forcing them to litigate similar issues in two jurisdictions, and risk inconsistent results. Further, because most of the insurers are involved in the California lawsuit, it is significantly more efficient for Harco to join the California lawsuit. California is a proper and more convenient forum for this coverage dispute. Dismissal rather than a stay is more appropriate here because Harco will be able to assert all its claims and defenses in the California lawsuit without being time barred and will not be prejudiced in doing so. Factual and procedural background. So the Harco policies, which they have been added to the docket as part of the complaint, but they are redacted. Harco issued a management liability policy to Wayfarer for July 15, 2023 to July 15, 2024. Didn't the sexual harassment, though, that alleged to happen was before July 15th, 2023. But I take their point about the 17-point document. Harco issued a management liability policy to Wayfarer for July 15th, 2023 to July 15th, 2024 policy period, and renewed that policy for the July 15th, 2024 to July 15th, 2025 policy period. Declaration of Alexandra Kaplan, dated October 24th, 2025, with certain exceptions, such as their effective periods, the policies are subject to nearly identical terms, conditions, limitations, and exclusions. The policies obligate Harco to defend any claim against the insured, even if the allegations in the claim are groundless, false, or fraudulent. Wayfarer is the name insured under the policies, and each of the other insureds are as insureds under the policies. The policies include A, general terms and conditions, private company; B, the directors and officers and entity liability coverage part; and C, the employment practices and third-party liability coverage part. Harco's limit of liability under each of the policies, inclusive of reasonable defense costs and fees, defined in the policies as defense costs, is $2 million for the D&O coverage and $2 million for the EPL coverage, for a total of $4 million for these two coverages. Harco's limit of liability for the EPL coverage includes an additional defense cost separate limit of $1 million. This additional defense cost limit applies to Harco's payment of defense costs under the EPL coverage without reducing the EPL coverage's $2 million limit of liability. The Lively lawsuit. This court is very familiar with the Lively lawsuit, and so is much of the public. Yes, we are. Given the widespread coverage in the media around the world. Therefore, we do not address here all of the issues and allegations in the Lively lawsuit. Suffice it to say that Miss Lively alleges myriad wrong acts on the set of It Ends With Us, as well as away from the set and unrelated to the movie. On February 18th, 2025, Ms. Lively filed an amended complaint in the Lively lawsuit. The amended complaint includes causes of action for, among others, retaliation, false light invasion of privacy, and defamation. Although Harco undoubtedly had notice of the lawsuit given its widespread coverage in the media, the insureds formally notified Harco on April 25th, 2025, and requested that Harco defend them and honour their coverage obligation under the policies. Harco denied coverage on June 20th, 2025. This coverage action. On July 21st, 2025, Harco filed this action seeking a declaration that the policies do not provide coverage for the Lively lawsuit. Harco seeks to avoid coverage on grounds asserting that the Lively lawsuit does not trigger the 2024 policy's liability insuring agreements because it is not a claim that was first made during the policy period. The 2023 policy does not apply because there is no coverage under its insuring agreements and it was not properly notified. There is no coverage under the 2023 policy pursuant to the 2023 warranty and 2023 prior knowledge exclusions. And there is no coverage under the 2024 policy pursuant to the 2024 renewal application and 2024 prior knowledge exclusions. It's such a technical mouthful to say all that. Okay, so the insured's California lawsuit. Just as Harco denied coverage, so too did the other insurers. Despite the broad promises of coverage in their policies, neither Harco nor the other insurers assumed their duties to defend the insureds or agree to indemnify the insureds for any settlement or judgment in the Lively lawsuit. Therefore, on July 30th, 2025, the insureds commenced the California lawsuit alleging breach of contract, bad faith, and seeking declaratory relief from the other insurers. The court should exercise its broad discretion to dismiss or stay this action under the Brill-Hart-Wilson doctrine. The Supreme Court has found that suits brought under the Declaratory Judgment Act justify a standard vesting district courts with greater discretion in declaratory judgment actions. The DJA states that a court may declare the rights and other legal relations of any interested party seeking such declaration. Indeed, since its inception, the Act has been understood to confer on federal courts unique and substantial discretion in deciding whether to declare the rights of litigants. As a result, the Supreme Court found in Wilton that a district court is authorized in the sound exercise of its discretion to stay or dismiss an action seeking a declaratory judgment before trial. The Second Circuit has elaborated on these findings, stating that courts have consistently interpreted the permissive language of the statute as a broad grant of discretion to district courts to refuse to exercise jurisdiction over a declaratory action that they would otherwise be empowered to hear. The essential question the court must ask is whether the questions in controversy between the parties to the federal suit can better be settled in the proceeding pending in the state court. When determining whether an action should be dismissed or stayed under Wilton and its predecessor, factors to be considered include the following. 1. The scope of the pending state proceeding and the nature of the defences available there. 2. Whether the claims of all parties in interest can satisfactorily be adjudicated in that proceeding. 3. Whether the necessary parties have been joined. 4. Whether such parties are amenable to process in that proceeding. 5. Avoiding duplicative proceedings. 6. Avoiding forum shopping. 7. The relative convenience of the fora. 8. The order of the filing. And 9. Choice of law. These factors need not all be considered equally, particularly when the omitted factors are either irrelevant or deserve less than significant weight in the case. Here, consideration of the Wilton-Brillhart factors weighs in favour of abstention. Harco's declaratory judgment action involves only state law claims with no federal interest. Harco's declaratory action does not involve any questions of federal law. Instead, it refers solely to questions of state law, namely insurance policy interpretation. New York federal courts have stated that insurance disputes generally present strong reasons for a federal court to abstain because such claims are intimately tied to matters of state law which are being litigated in state court. Additionally, when, as here, an action raises only issues of state law and does not implicate substantive federal law, this factor weighs heavily in favour of abstention. This is further supported by the notion that Congress has long explicitly exempted the federal government from regulation of the insurance industry. Thus, the fact that Harco has only raised state questions counsels strongly in favour of abstention. The California lawsuit is the proper and more convenient forum. While Harco is not currently involved in the California lawsuit, that proceeding is more than capable of encompassing Harco as an additional defendant, and the insureds intend to bring claims against Harco in the California lawsuit upon the dismissal of this lawsuit. Footnote: while Harco's federal action was filed slightly before the California lawsuit, courts agree that the timing of the filing is a non-issue as it pertains to abstention under Wilton. While the parties may not be identical, the questions at issue mirror each other. Indeed, there is only one loss suffered by the insureds in connection with the same underlying lively lawsuit, and the defendants in the California lawsuit are the other insurers that denied coverage for the same defense costs, just like Harco. Harco will also be able to raise any claims that it has raised here as defenses, affirmative defenses, or counterclaims in the California lawsuit. Thus, abstention is proper under Wilton, given that Harco falls well within the scope of the pending state action, and all of Harco's claims can satisfactorily be adjudicated in the proceeding. California has a particular interest in ensuring the proper application of its insurance regulations and law. The key question is which jurisdiction has the greatest interest in litigation. Factors to consider include the place of 1. Contracting, 2. Negotiation of the contract, 3. Performance, 4. The location of the subject matter of the contract, and 5. The domicile, residence, nationality, place of incorporation, and place of business of the parties. Here, Wayfarer and It Ends With Us movie have their principal places of business in California and contracted the policies in California. All but one of the members of Wayfarer are citizens of California. Mr. Baldoni and Mr. Heath both reside in California. Harco is not incorporated in New York, nor does it have a principal place of business there. Rather, Harco is incorporated and has its principal place of business in North Carolina. Further, the majority of witnesses for the two coverage actions will likely be located in the California area. Two lawsuits would force these witnesses to appear in multiple actions across the country from each other. In addition, document production would be doubled and parties would be asked to produce documents twice. Such waste of judicial resources strongly favours abstention. Because California is the more proper forum, this action should be dismissed or at the very least stayed. Abstention will avoid duplicative proceedings that could result in inconsistent rulings. The avoidance of duplicative proceedings and piecemeal litigation also weighs in favour of abstention here. The Supreme Court has discussed avoiding piecemeal litigation as a factor, favouring staying or dismissing a suit where parallel proceedings are underway in state court. The Second Circuit also routinely analyses the risk of piecemeal litigation and duplicative proceedings when deciding whether to exercise abstention. Here, there is a substantial risk of duplicative or contradictory fact-finding between this action and the California lawsuit. Both this action and the California lawsuit involve efforts by insurers to avoid their duties to the insureds with respect to coverage for the lively lawsuit. Therefore, the disputes arise out of the same factual nexus. Both disputes inherently involve the assessment of the same underlying facts, namely, who knew what, when, with respect to the events in the lively lawsuit. As the lively lawsuit and the California lawsuit are both ongoing, it simply makes no sense to have an additional coverage action for declaratory relief proceeding simultaneously in New York federal court. Allowing this lawsuit to continue risks duplicative costs for the insureds, duplication of court efforts assessing the same underlying facts, and prejudice for the insureds. Further, it could lead to inconsistent results which would be patently unfair given the similarity of the underlying issues. To avoid duplicative results, inconsistent outcomes, and piecemeal litigation, this court should dismiss this lawsuit in favour of the California lawsuit. Harco's federal lawsuit constitutes impermissible forum shopping. Harco's declaratory judgment lawsuit filed in federal court constitutes impermissible forum shopping. The New York federal courts recognize that in other cases involving such blatantly anticipatory declaratory suits, courts have frequently exercised their discretion to abstain. Indeed, if a party files a declaratory action with knowledge that its adversary is about to bring a coercive suit, then the object of the declaratory action cannot be to obtain clarification of disputed rights, because the declaratory plaintiff is well aware that those disputes are about to be submitted to a court. Further, Harco went so far as to file a lawsuit before allowing the insureds to respond to its initial denial of coverage. As discussed above, California state law is the proper and appropriate forum for this coverage litigation. All but one of the defendants is a citizen of California, and both of the businesses implicated have their primary headquarters in California. Harco has brought suit in New York in an apparent effort to secure a forum that it believes is more insurer-friendly than California. Numerous courts in this circuit have time and again reminded insurers that the Declaratory Judgment Act should not be used to gain a procedural advantage and preempt the forum choice of the plaintiff. Such strategic gameplay counsels strongly in favour of abstention. Harco's action should be dismissed rather than stayed. Dismissal based on abstention is proper where there is no risk that the federal court plaintiff's claims of non-coverage might become time-barred as they may be asserted in defence of any claims under the applicable policy. Okay. Here, as discussed above, Harco will be able to assert all of its claims and defences in the California lawsuit and will not be prejudiced in doing so. There is no risk that Harco's claims will be time-barred. Accordingly, the dismissal of Harco's action rather than a stay is appropriate. Conclusion. In accordance with the Brillhart-Wilson doctrine and for the foregoing reasons, the insured respectfully request that the court grant this motion to dismiss, or in the alternative, stay this action while the California lawsuit continues. Okay, so Harco will get a right reply. I think it's in 7 days from this, so that'll be tomorrow. Is that tomorrow? Yes. So we will see. I'll check that out when we receive that and see what they say, and then it'll come down to what the judge says, whether they're going to dismiss it. In which case, Wayfarer will, as they say, will pick it up and add them to the California lawsuit that's already ongoing with the other insurers. Okay, so that's it from me for this evening. Have a good evening.